Could the appellate court say, we understand he wasn't prepared, but he could have asked for another delay of the trial and he didn't? Yes. Generally, by not asking for a continuance before trial, an appellate court would likely see that you not asking a continuance is saying that you gave up that right. But there's exceptions. As an attorney, you were so incompetent, no amount of time would get you up to speed, or 2, the lack of preparation was because of a lack of information. You can't use to prepare what you didn't have. If the prosecutor hid something, no amount of time would allow you to prepare for that. Here, in this particular case, I swear they asked for more time before he started trial, but I could be wrong on that. I haven't looked it up before responding to this. So if he did say, I don't need more time to prepare, let's just go to trial, and now they're saying he didn't have enough time to prepare, that would not allow an appellate court usually to say that he needed more time. But if the argument that he was incompetent, the attorney was incompetent in saying he needed more time, that may go to why you would need a new trial. Is it required that the previous attorney prep the attorney that is taking over? And I'll give you the number one lawyer answer, yes and no. It depends on the context of the representation. Generally, as a client, you have a right to any and all work an attorney did for you that you paid for. That means going to the next attorney, they have to turn it over. You bought it, you get it. Sometimes it costs money to wrap up or to give it over. You owe that if you want your next attorney to have the work that they did. Some can be court mandated as far as what the work the attorney has to do to clean up to give to the next attorney, i.e. redact the addresses, taking out personal notes, taking out schedules that maybe don't have anything to do with your case but someone else's, new information but have other clients' information. But the reason for the second attorney is usually that you don't like or you don't trust the first attorney. So often you don't really want any in-depth training. You want them to say, here's the paperwork, here's my quick summary of where I was when I did it, here's a list of people you might want or need to call, and finally, quote, call me if you have any questions, end quote, if even that. Thank you very much. That's sort of the extent of what you're required to do when another attorney comes on the case. But if the other attorney doesn't want to hear it, or if you don't want the new attorney to hear it, then you can always give up the ability for them to explain as to the old, from the old attorney to the new attorney, as far as where it goes. So how much is it required? That's a really good question. It changes per case.